All right, and we're here for sentencing on charge of malicious destruction of personal property over $1,000. It's punishable by a maximum of 5 years in prison. The guidelines have been initially scored at 0 to 6 months. Mr. Gilbert, have you had a chance to review that report and recommendation with your client?
Yes, we've reviewed the report and the recommendation with my client. We have no additions or corrections, and we have no challenges to scoring.
Mr. Juliet, any additions, corrections, or scoring challenges from the people?
No, yeah.
Mr. Gilbert, anything you'd like to say on the client's behalf?
Yes, I would point out that Mr. Heffner would like me that he has been addressing. I believe there was some, it's reflected that there's pending charges or issues with Mount Pleasant and Saginaw. He has been in contact. I believe Mount Pleasant was resolved and Saginaw is in the process of being resolved. They know where he's at and he's been addressing those items. In addition to that, Your Honor, we asked if the court followed the recommendation. I believe Camden has learned his lesson from this. As the court knows, he does have another pending case, but I think this time in jail has been a very big eye opener. Prior to this, and I know he's conveyed this to me on many occasions, prior to this, he never really had a jail experience. I mean, he's a young man, and this is the first one he's really had. And I think it was an eye opener. He's in there with people that he doesn't necessarily want to be around or be like. There was one instance in another case, and I know the court saw the video. When I saw the video, I was very proud of Camden. There was a fight in the cell. What does Camden do? He hightailed it as fast as he could away from that, so he wasn't involved. And there's me watching it as I saw what was happening. I was very proud of what Camden did. That Camden that I knew years ago in the juvenile court probably would have been involved with that. And so I think this has been an eye opener. And he does understand that he has to get his temper under control. He does have a temper issue, but again, the jail has been a very big learning experience. Thank you.
Thank you, Mr. Heffner. You don't have to say anything today, but you're welcome to. Is there anything you want to tell me or no?
No.
Okay, Mr. Juliet, any recommendations from the people?
I would ask the court to follow the recommendation for the probation and credit for time served. In this case, the defendant's 19 years old and he's already got his first felony. He has significant juvenile history. I remember because I was the prosecutor in most of those cases. Now he's got more pending felonies, so I certainly hope this was not an eye opener. I'm not going to rehash the facts that the court set for this trial, so I ask the court to follow the recommendations.
All right. Well, this is a really hard one, Mr. Heffner. We did have a trial in this case, and this was a very serious offense. When I think about what's an appropriate sentence within a guidelines range, we've actually had some cases today where we think about, well, gee, other conduct that would have been worse would have still been in the same guideline range. And here, other conduct that would have been far less serious would still be in the same guideline range. If you had keyed Mr. Hush's car, you'd be here convicted of the same offense with the same guidelines range. But this was a pretty frightening situation. You were at a outdoor party gathering that had a bunch of young people there, and some of them fueled by alcohol, I'm sure. And then you gather up a crowd of people to go get someone as they're trying to leave in their car. And their car is surrounded while you and others that you have riled up are pounding on it, kicking it, trying to pull them out. And what were you going to do if you got them out? Beat them up. And there's a girl with them in the car. What's going to happen to her? That's a very serious malicious destruction of property case. For anybody inside that car, that'd be a terrifying situation. It's not just you on the outside, it's the other folks that you've rounded up. And then I look at, okay, that's the seriousness of the offense. What about the seriousness of the offender? I know this is your first felony conviction, but you've been busy. In the juvenile court, you had a 2021 MDOP misdemeanor dismissed after a delay. So you're put on probation for destroying somebody's property or damaging somebody's property 4 years ago. Then the next year, receiving, concealing stolen property and a home invasion. And then the next year, 2023, guess what? Another malicious destruction of property misdemeanor. Then you get discharged from juvenile probation in April of 2024. Within 4 months, you commit this malicious destruction of property, a felony, that I consider a very serious event. Then while the case is pending, in October of 2024, you get an assault and battery charge out of Saginaw, for which you're ultimately convicted and get probation. Then, in August of 2025, you get a felony resisting obstructing police charge in Isabella County that's scheduled for court next week. And then in September of 2025, back in this county, you're charged with discharging a firearm from a moving motor vehicle, and you're set to be arraigned by me next week. My goodness, I mean, Mr. Heffner, that's a young man that is just out of control, and being on juvenile probation didn't slow you down. Being on felony bond didn't slow you down. So what's it going to take to slow you down? So your lawyer's telling me you sitting 83 days in jail has changed your life, and now you're going to stop doing this stuff. Why should I believe that to be true? Is there anything you got for me today? Like, what have you learned?
That jail isn't somewhere that I would like to be. I need to be there for my son, and that I need to do better in life. And I see that I don't want to be like these people in jail going to prison. I don't want to be. I want to change. I want to do better. I know I have a drinking problem. I need to get like some sort of rehab, some sort of something. I know that. And I reached out to an outpatient, and I was accepted to one. It's just depending on what happens here today.
All right. So I honestly don't know what to do, Mr. Heffner. I mean, well, we've got a couple pending contempts for the pending charges. I mean, I'll dismiss both of those pending contempts. We're here for sentencing on this one. The other cases are still pending, so it doesn't make any sense to proceed with those contempts. But then, you know, I'm really torn here with what to do, because, you know, I want to make sure that what I'm doing when I'm here on this bench is keeping the folks in town safe. I also am looking at a young man who's 19 years of age. I don't want Mr. Heffner to draw a lesson at 19 that the system only exists to come down on him like a load of bricks. You know, I do want to hold out hope, given his youth, that probation can help. But, you know, that's only going to be if you participate. You know, probation isn't going to make you any better unless you participate in what's going on. So I don't know. I mean, I think I have to kind of combine some things here. So I think taking all these things into account, what I'm going to do, Mr. Heffner, is place you on probation for 2 years as recommended. That's subject to the terms and conditions listed on pages 2 and 3 of the pre-sentence report. I want to highlight some of those conditions for you. You have to complete a substance abuse assessment when you're referred by your field agent, and outpatient or residential substance abuse treatment when you're referred. You have to participate in adult education or GED. So we want you to finish your education. We want you to get sober, stay sober, get treatment for that. No contact at all with Mr. Hush. We want you to get a job, full-time employment, and keep a job. There's a restitution, but that was paid by the co-defendant, so I don't think we can double dip on that, and it'll be up to the co-defendant to sue him for contribution, I think.
I agree.
Okay, so I'm not going to assess any restitution, so that's at zero. It's been paid by the co-defendant. There's a crime victims assessment of $130, court costs of $350, state cost is $68. You have to comply with DNA testing and pay a $60 fee, and there's a monthly supervision fee to the Department of Corrections. I'm going to, Agent Martin, I'm going to add a couple terms of probation. Because Mr. Heffner's been cruising around without much regard for the community, I wanted to do 100 hours of community service. And I want him to have a curfew. And and at did I say 0 to 9? It was 0 to 6 months. Okay. You know, Mr. Heffner, you are on a fast path to significant incarceration, including prison. So I do think, given the seriousness of this situation and the pattern of behavior that brought you here, I'm going to order that you serve 5 months in the Sheboygan County Jail with credit for 83 days previously served. And it's within the advisory guidelines. I think it is, there's reasonable grounds for incarceration despite the intermediate sanction because of his pattern of behavior up to this case and the pattern of continuing criminal behavior while he was in bond in this case. And Mr. Heffner, you are entitled to appellate review of this conviction and sentence as a matter of right. If you are unable to afford a lawyer, I would appoint one to represent you on appeal, but you must file the request within 42 days after entry of the judgment of sentence if you want to appeal by right. We're going to hand you a piece of paper explaining that, ask you to initial one copy, the other one's for you to fill out if you want to appeal. And also you're eligible for early discharge from probation at the halfway point if you've successfully completed all its terms. We're going to hand you a piece of paper explaining that process. Within 24 hours of your release, I want you contacting your supervising agent, okay? And if you violate probation, you can expect a lot more time from me. All right, good luck, Mr. Heffner.
I think the judge made the right call. Tough but fair. What do you think? Tell us in the comments. And don't forget to subscribe for more crazy courtroom moments.